last few years, and due to a plethora of reasons, we have seen a tremendous interest amongst our clients to draw up a comprehensive succession plan for their business as well as personal assets. Among the various succession tools available, one of the most easiest and simplest to understand is the will. Every individual, regardless of the size of the wealth, should always have in place at least a will. The procedure is extremely simple. It can be made on a simple piece of paper and does not require to be stamped or registered. It can even be handwritten. However, it needs to be witnessed by 2 witnesses. A will would grant an individual the freedom to choose their heirs. Otherwise, intestate succession in India is governed by the religion professed by the deceased. There are predetermined heirs who would otherwise inherit a person's assets in fixed proportion as determined by the law. This may not always be desirable or favorable. Today we will discuss a few tips and tricks to make a robust will and few mistakes which are commonly made and should be avoided. First, clearly identifying all assets belonging to the individual. A complete and accurate description of the same is preferred. If this is too cumbersome, the balance sheet of the individual or the income tax return should be annexed to the will. Next, identify an executor in the will. The executor is a person who is responsible for the administration of the deceased estate. Name someone who is younger than you and has at least a brief understanding of your estate. We would also recommend naming 2 independent witnesses who are not legatees under the will. In instances where the witnesses and legatees are the same persons, the courts have held that the testator may have been under undue influence. If there are substantial assets held by a person in more than one country, it is recommended that the separate wills are made for each of such jurisdictions. This would ensure that the assets in one jurisdiction are not withheld from administration due to cumbersome procedure of probate in other jurisdictions. Importantly, review and revise the will at every major milestone, such as on disposal of certain assets or acquisition of substantial assets, or birth, marriage, or death of an individual. However, it is extremely important to destroy all other previous will made and that there is only one last and final will for an individual. If a new will is being made, such will should specify that it revokes and cancels any previous will made by the testator. Specific references to the previous will may be made to this effect. Last but not the least, do not use templates that are easily available online. There are nuances to each succession planning document which should be discussed and finalized with the help of a qualified lawyer. Given that in most cases the will is the most important succession planning document, it is always better to consult a lawyer prior to finalizing the same.